happened until several months after Mr. Crute was cited.
Right.
So in his position, all he knows is that the state's rule is what it is. Judge Conley made an injunction, but it doesn't change the requirement of the rule. It doesn't tell him whether the state is going to follow the injunction, whether the state is considering some type of interlocutory appeal, whether the state agreed or disagreed with Judge Conley's decision. It doesn't give them any information about any of those things.
The state did follow the Conley injunction, and it was a ruling that was followed.
Well, I guess my question is, wouldn't it only have been reasonable for the state to someplace announce that, announce what their construction was of that rule, and the easiest way to do it would be simply to do another emergency rule?
You know, I don't know if that's the only simplest way to do it. I believe in all of the cases the participants were warned that the assembly was larger than permissible under Conley's decision, and they had an opportunity then to comport their behaviors to the decision.
I guess this, what you just said, maybe presents another question, which is, when a court issues a ruling of the sort that Judge Conley did, sometimes there can be different interpretations, and you understand what his ruling said was that it would enjoin or prevent the state from enforcing the permitting requirement as it applies to gatherings within the capital that are anticipated to attract 20 or fewer persons. But it's really not the way the state applied that, is it? Because the state applied it as to any situation where, in fact, the gathering reached a threshold of more than 20, whether or not it was anticipated.
Right.
But don't you agree that those are two different things? And in other words, somebody in good faith could go to the rotunda intending to sing. They don't know how many people are going to be there. For all they know, they want to sing by themselves, okay? Maybe there's going to be some other people there, but they don't anticipate it's going to attract 20, or more than 20 people. So they don't get a permit. In fact, it does. And that's when the state decides that they're going to enforce it under penalty of their getting the civil forfeiture.
Yes.
So, don't you agree that that's a different circumstance than the one that Judge Conley contemplated with his injunction? Because he said you need a permit, that the state can enforce this for gatherings that are anticipated to attract more than 20.
Right.
Okay, but that's not the way that the Capitol Police enforced it, though, is it? Because the Capitol Police waited until it got to 20, and then they said all of those people are subject to the forfeiture. Right?
Yes.
When in fact, those people could have gotten there anticipating in good faith that that gathering wouldn't attract as many as 20.
But in fact it did, and I think, in fact, counting more than 20 is much more reliable than anticipating whether or not something will be 20 or more. If a person comes in and joins an event that you can clearly see is more than 20, that person upon walking in can anticipate it's more than 20.
Well, how would that person then know? Okay, number one, she hasn't anticipated it would be, and that's in good faith. And that's what the Conley decision looks at. But how would the person know whether anybody else in this gathering might have gotten a permit?
I'm sorry?
Well, maybe somebody else in the gathering took it upon themselves to get a permit. Somebody who comes along later, they don't know, number one, till they get there, how many people there are going to be. They don't know whether, if there are more than 20, they don't know how the department is going to enforce the rule. They don't know if there are more than 20 and the department is going to enforce its understanding of the rule after the Conley case, whether somebody's gotten a permit. So there's a lot of uncertainty and a lot of question before that person participates in the event that they're there to participate in, or to sing. Is that true?
I would guess that's true, yes.
You make the point, and it's a good one. The state absolutely has legitimate interests in enforcing a permit requirement at some point. And we get into issues primarily of order and that type of thing. Judge Conley talks about, and Mr. Crute's point is that this rule is not narrowly tailored to address those issues, because it takes in way too much speech, I think as Judge Conley said, or something like that, than would be justified by the proper legitimate purpose of the rule. Do you remember when Judge Conley said that? Remember he made some comment like that in the decision?
Which comment are you talking about?
Well, just that it's not narrowly tailored to address the government's legitimate interest, because it takes in vastly more expressive conduct than it would need to in order to satisfy the government's purpose.
Right.
The question I have for you is, why can't all of those purposes simply be addressed by applying other rules we have on the books to deal with disorderly conduct and other offenses to public order? If people become unruly, if there has to be an increased police presence, if it becomes disruptive, we have ways of dealing with that. So why aren't those ways sufficient?
You know, Your Honor, I don't have information that I can respond to that. I think there are other laws that can be relied upon. I think the Department of Administration did fulfill its duty in making administrative rules. And I can't answer for people who were in the position to make those decisions. I don't know.
Mr. Olson, the state's claim, as you have identified earlier, is that I shouldn't find this to be facially unconstitutional because I need to look at how the state actually applied the rule, and Judge Conley, preliminary injunction, intervenes. Can't we assume that the state's going to comply with the Judge Conley injunction, and where I anticipate, because I've been going to these things, that there's typically more than 20 people there over the noon hour singing, shouldn't I be able to guide myself by the Conley rule and know then that the state would issue me a citation because there's more than 20 people there?
Well, as we pointed out in our briefing, as Your Honor certainly understands, the state wasn't even abiding by the Conley preliminary injunction because it wasn't deciding who to cite based on whether the groups were anticipated to be larger than 20 people or not. And all of the authorities that deal with the question you're raising say that a history of limited enforcement of an overbroad enactment doesn't insulate it from a facial challenge, because the very presence of the overbroad law on the books has a chilling effect. Let me try to wrap up some of the concerns that you were discussing a moment ago in a scenario that I think might be helpful. Let's say I'm a member of the Bad River Band of Native Americans up near Lake Superior in the vicinity of what's planned to be a new mine. And I'm very concerned about the potential pollution of the waters in our little area of tribal land. And I get together 2 minivans full of other Native Americans, and we want to go down to the Capitol and have a 12-person demonstration in favor of protecting our tribal lands in the Capitol Rotunda. And I want to figure out whether I'm going to need a permit for my 12-person demonstration or not. And here's the attitude that I take going in. If I'm going to have to get a permit, I'm not going to do it, because I don't want to assume the responsibilities, including the financial responsibilities talked about in the access policies that come with signing a permit. And I don't want to represent myself as responsible for the behavior of these other people that are going with me. So I'm happy to go down and demonstrate with my group of 12 if I don't have to get a permit, but if I have to get a permit, I'm not going to go. So what do? I look on the internet and I see what I can find that governs who needs a permit to demonstrate in the Capitol. And I find the Wisconsin Administrative Code provisions, including the one at issue here, that say you need a permit for any demonstration at all, even a group as small, an assembly as small as 2 people. So it looks like I need a permit, so I decide I'm not going to go. But if somebody says, well, you should look beyond the administrative code, so I look at the access policies, which are also available online. And the access policies say you need a permit for a group as small as 4. So I decide not to go. And somebody says, well, I heard that there was a preliminary injunction. And I say, okay, I can look that up. And I say, well, here they're enjoined from enforcing this against people who are going to have an event that's anticipated to be less than 20. There's a federal court order that prohibits enforcement against an event anticipated to be less than 20. So you can go. But then somebody else says, well, wait a second. I heard that's not what's going on in the Capitol. Even if you anticipate that you're just going to have the 12 people you're taking down in your 2 minivans, if you're in that Capitol Rotunda and you attract sympathizers to the point where your gathering gets to be 21, they can cite you all for not having a permit. And it's true that they may warn you, but if you've got stubborn people who are not going to leave when they get that warning, you're going to have hauled people down there to get cited as part of a gathering that is protected by this federal preliminary injunction, and they're going to be cited anyway. It's protected because it was anticipated to be less than 20, but you're going to be cited anyway. So then I decide, well, maybe I'm not going to go, but I want to ask the Capitol Police what they're doing. So I call long distance to Madison, I talk to somebody in the Capitol Police, and I say, what are you doing? And they said, well, we're not exactly following the preliminary injunction because we never ask anybody how big their gathering was anticipated to be. We just count up to 20 people, and then if we declare it unconstitutional when it gets to 21, we declare it unlawful assembly when it gets to 21. So I say, well, maybe we can all take signs that say, please don't join our gathering. Because if we get over 20 people, we're all in hot water. But then I say to the Capitol Police, you know, that may be the way you're doing this today, But how do I know you're going to be doing it that way next week when I get my 2 minivans of Native Americans down there? Is this written down anywhere? And he says, no. And I say, well, you did emergency rules in April. If there's anything that constitutes an emergency, it would seem to me to be a federal court decision that your administrative code provisions are unconstitutional, most likely. But you haven't done any emergency modifications to these rules to tell me that even if I keep my gathering under 20, I'll be safe from arrest. You could issue access policies without any red tape at all, as you did in April, and you haven't reissued your access policies to tell me that I'll be safe if I keep my group to under 20. All I've got is word of mouth on what your day-to-day practice is. I'm sorry, I cannot take the risk of bringing my Native Americans down to protest water pollution. That, Your Honor, is a perfect example of chilled speech, and that's what our constitutional jurisprudence that declares these provisions unconstitutional on their face is designed to prevent. Thank you.
Ms. Olson. Ms. Weise, what do you say to that? The burden is on the state, so I'll give you the last word.
The state's position is as laid out in the written submissions that have already been filed with the court.
Okay. Thank you very much for your arguments and briefing, and I will have a decision on that, as I indicated earlier, within the next 30 days. And the argument was helpful today, as were the briefs. I very much appreciate that. Mr. Olson and Mr. Crute, you can certainly be excused, or you can have a seat, perhaps.